Now, we have been told by our chairman that within a few years the United Kingdom will have disappeared. We will have left the European Union, and he probably had wanted to add, had he had a second egg for breakfast this morning, we would have withdrawn from the European Convention of Human Rights, I presume, as well. So radical changes in the offing indeed, which makes me hesitant to pronounce the first line I had intended to offer, which is plus ça change. All that changes, all that remains the same on this election morning. We are looking this morning at, over these 2 days, at the issue of democracy in international law, its relevance. And this is an issue which, certainly since 1945, has been around and has been discussed with some vigor. You recall the UN Declaration on Human Rights, which says what? The authority to govern shall be based on the will of the people. And it was, it seemed, an uncontested statement. A statement that to us seems as natural as it appears to lack reflection in actual lived reality, where we all know that at least until the adoption of the Universal Declaration, that the principle that used to be applied to issues of governance from the perspective of international law was not legitimacy or democratic credential, but it is the well-known Tinoco principle of effectiveness. We look at whoever exercises authority in the most effective way, and that is the source of authoritative representation of the state externally and the sovereign authority of governance internally. So that for some time we have lived with this dichotomy that all governments around the world have professed adherence in an unqualified way, unanimously, without any exception whatever, to the principle of democratic governance. But at the same time, in actual practice, we've seen that this principle does not seem to have been reflected in lived international reality, at least outside of a club of sort of northern, Western type governments mainly. Yes, in 1966, we had the Covenant on Civil and Political Rights, which expanded on the idea that the authority to govern shall be based on the will of the people, and which added this idea of genuine and periodic elections as the means of establishing the will of the people on which governance is to be based. But then again, what is genuine periodic elections? The one-party state would argue that the only way through which the peasants and workers can best reflect and transmit their will is through a one-party system, where we don't have these disturbance of reactionary debate and counter-revolutionary tendencies. So it was possible to maintain the fiction or the view that the principle of democratic governance lies at the heart of what we understand to be the state as the basic constituents of the international system, without really having a clear sense of a real meaning of this concept. Something that seemed to change in 1990, when we had the end of the Cold War, when the Conference on Security and Cooperation in Europe transformed itself under the Paris Declaration into an organization dedicated to this principle of genuine periodic elections, but also in Latin America, in other places. Even the UN General Assembly started adopting declarations on the principle of genuine and periodic elections. So it seemed that at that point we were seeing a rebirth of this principle. And this was reflected in scholarship. Famously, Thomas Frank, in his article in the American Journal of International Law, opened this debate. And then, yes, Cambridge is pushing forwards the frontiers of international law, but James Crawford, the incoming Whewell professor at the time, in his inaugural lectures pushed the boundaries backwards a little bit by arguing that democracy, after all, is not such a powerful, firmly entrenched principle in international law, at least at that point. Now, some 25 years after 1990, the official end of the Cold War, it is really extremely timely to return to this issue, to examine the Frank and the Crawford thesis, to look at international law as a governance principle internally within states, but anchored, at least supposedly, in the international legal order. We also often hear debates about democracy in international law in a different sense. The question of the equality of states and the way decisions are taken in the international system. Is that truly democratic? Should we reform the UN Security Council? Is it fair that in some international institutions we have weighted voting according to financial contributions? All sorts of questions affiliated with this. In addition, the conference program reveals a number of interesting contributions on the boundary between comparative law and international law. Now, as we contemplate the principle of democracy in international law, we are, of course, aware of the fact that even if there's a rule of democratic governance in international law, which I certainly firmly believe there is, that behind these kind of labels and titles and purported legal rules, there hides a contestation about values. And even if we think that we know there is a legal rule, underneath this contestation continues. And that is, of course, a discovery which we owe in part to the Yale School of Jurisprudence. Dame Rosalyn Higgins, or should I say Professor, Judge, President, Dame Rosalyn Higgins, she combines the best of all possible worlds because she obtained a first in her bachelor's and what now would be, I think, the LLM degree in Cambridge here. She then ventured off to Yale, did her SJD there, and then returned here to, as you know, an extraordinarily distinguished career in public international law. A career that included her tenure as chair at the London School of Economics, where, in a sense, she created the profile for this chair that to this day persists. Her time at the court as judge and then president is well known to all and greatly appreciated. And, of course, she has been contributing very major books in our area. Her books on the development of international law through the political organs of the United Nations. I remember the excitement when I found a copy, it was out of print, of it in a bookshop here in Cambridge. Many contributions of similar quality have followed since then. She has been showered with honors, medals, prizes, honorary doctorates, including one from Cambridge, of course, and even from Oxford. So who better to give us a sense of the balance between the relative normative value that is derived from the underlying contestation about what democracy in international law really means, and on the other hand, the normative certainty that we can derive from our knowledge that this rule actually does exist in international law. And I'm much looking forward to seeing that balance struck by Dame Rosalyn now. Thank you so much.
Good morning, and my thanks to Professor Fentman and Professor Weller for their words. I do find this a remarkable conference to be at. Annika Seaman and her colleagues have been models of efficiency and helpfulness that professional organizers could be proud of that. And looking at the program, it is so interesting. I think you're all in for a couple of splendid days, and I too have been struck by the fact that you've come often far and wide to be here. I'm also pleased to be in this remarkable building, which did not exist, at least in this state, when I was up a lifetime ago, and it's a pleasure to be speaking in this lovely lecture hall. Now, in what I have to say this morning, it will become apparent that democracy cannot, either legally or politically, be usefully talked about without also talking about human rights and the rule of law. As we'll see, these are unavoidably interrelated, so I will have to wander down some other highways and byways. Indeed, we will need to see if we should really think, partly what Professor Weller was saying, of democracy as a legal right at all. I'm much less certain than he. And also briefly to take a look at its state of health at the present time. So let's make a start by looking for the sources of international law which might suggest this concept of democracy. The United Nations Charter makes no mention of the word democracy. Some say that the idea of democracy is to be read into the opening words of the Charter, that is, we the peoples. There is something to this important reference to the entitlement and desire of we the peoples, especially as membership of the United Nations has always been one of states. The point of departure has been Article 4 of the Charter, which, as you know, provides, first, membership of the United Nations is open to all other peace-loving states which accept the obligations contained in the present Charter and in the judgment of the organisation are able and willing to carry out those obligations. 2, the admission of any such state to membership in the United Nations will be effected by a decision of the General Assembly upon the recommendation of the Security Council. Absolutely no reference in these words to a state needing to qualify for membership to be democratic. More generally, the Montevideo Convention on the Rights and Duties of States, still regarded as the classical statement on the subject, stipulates that the state as a person in international law should possess the following qualifications: A, a permanent population; B, a defined territory; C, government; and D, the capacity to enter into relations with other states. The emphasis is thus on realism, on effective control. And this immediately feeds into the question of recognition, which you'll be relieved to know is beyond the scope of my talk today. As you will know, there are those who say that the recognition of a state must depend upon the criteria of statehood being met, and there are those who say that recognition by others is itself a prerequisite of statehood. I think there is some truth in both perceptions. But the essential point for us today is that none of that debate is about democracy. Democracy is not in international law a requirement for statehood, nor indeed for recognition of statehood. And it could not have been otherwise. The whole point of the United Nations was for it to be an inclusive organization where the problems of the world could be addressed. And at the time of the inception of the United Nations, the vast majority of its membership was made up of states that were not democracies. What do I mean by that? That the will of their people was not reflected in the acts of those who governed. Of course, the meaning of state has indeed somewhat varied over the years, and its definition has been contextual. The Charter of the United Nations itself mentions the term state no fewer than 31 times. These mentions obviously do not all relate to admission for membership. The term is also used in the context of claims to appear before specific organs of the United Nations, to participate in certain specialized agencies, to bring matters affecting peace and security to the notice of the United Nations, to be a party to the statute of the International Court of Justice. So it's been possible to say that what the United Nations itself treats as a state is more rigorous than the functional answers of certain specialized agencies. And mechanisms have been found over the years for non-state entities to appear before bodies where their presence, normally reserved to states, has been thought desirable or even essential. Even the International Court of Justice, appearance before which is clearly limited in its statute states, has found ways to hear, in particular cases, Palestine and Kosovo. It required some cleverness on our part to achieve it, but it was so sensible a thought that it was done. And I noticed just the other day on the question of the joining of Palestine to the ICC statute, and the issue of that statute apparently being limited to states, that the special rapporteur has said that the special status of Palestine within the UN is sufficient to set things going there. But none of these developments has related to democracy. That's been a different question altogether. Even in the fraught problem of Kosovo, whether its declaration of independence was in accordance with international law, democracy was not the key. So, if statehood and democracy have no direct relationship, and the UN Charter has rather little to say on democracy, where has the great push underlying the promotion of democracy come from? Well, democracy is indeed mentioned as a value of great significance in other important organizations. The preamble to the Council of Europe refers to freedom and the rule of law as forming the basis of all genuine democracy. Interestingly, the preamble to the European Convention on Human Rights refers to the common heritage of the European governments and makes mention of freedom and the rule of law, but not democracy. The OSCE basic document states democracy is an inherent element in the rule of law. The OECD, referring to the rule of law, identifies various key elements and adds, the law can be changed by an established process that is itself transparent, accountable, and democratic. The way in which several concepts are intertwined is evidenced in Article 2 of the Treaty of the European Union, which provides, I quote, "The Union is founded on the values of respect for human dignity, freedom, democracy, equality, the rule of law, and respect for human rights, including the rights of persons belonging to minorities. So it's clear we will need to say something about human rights and also about the rule of law if we are to examine further the idea of democracy. So let me now say something about human rights and democracy. We've seen already, I think, how democracy, human rights, rule of law, intertwined concepts, each depending on the other two for its realization. The relevant human rights are above all those concerning self-determination in its broadest sense. The Universal Declaration of Human Rights, imprecise in the formulation of its terms, technically non-binding but widely invoked, projects the concept of democracy by stating, I quote, "The will of the people shall be the basis of the authority of government." And it lays out the rights that are the bedrock of effective political participation. As with the term democracy, the Charter contains few references to self-determination. The references in Article 1, 2 and 55, which couple equal rights and self-determination of peoples, suggest, as I've had occasion to elaborate elsewhere, that it was equal rights among states that was being referred to, not equal rights of individuals. So self-determination was a concept cautiously drafted in the Charter. In due course, the relationship of self-determination with decolonization came to the fore, though for some years the colonial powers insisted that self-determination was a political aspiration rather than a legal right. By 1971, the International Court of Justice held that the principle of self-determination was applicable to all non-self-governing territories. That was in the legal consequences of the continued presence of South Africa in Namibia case. And it was not to be understood as a right to independence. It was a right for peoples to choose their own destiny, including at the moment of independence, joining with another country if they so chose. And I refer you here to General Assembly Resolution 1514. While the concept of self-determination had its origins in colonialism, it was gradually to be realized as applicable as a human right. In 1966, the text of the Covenants on Civil and Political Rights and on Economic, Social and Cultural Rights provided that, I quote, "all peoples have the right of self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development." And the famous Helsinki Final Act of the early 70s makes it absolutely clear that, I'm quoting again, all peoples always have the right to determine when and as they wish to pursue as they wish their political, economic, social, and cultural development. Nor does the African Charter on Human and People's Rights limit the right that all peoples have to self-determination to situations of decolonization. It has spread beyond that. The Human Rights Committee under the International Covenant on Civil and Political Rights, has consistently told states appearing before it for examination of their periodic reports that the right to self-determination requires that a free choice be afforded to peoples on a continuing basis. It has also made clear that this is virtually impossible in a one-party state. Even in one-party systems that allow some form of participatory democracy, outcomes are predetermined. It hardly needs saying that minorities have minority rights under Article 7 of the Covenant, but that does not give that minority a so-called right to self-determination, and still less a right to secession. These legal issues, somewhat beyond the scope of this lecture, are dealt with in depth in the reference regarding the secession of Quebec case in the Supreme Court of Canada, 1998, and if I may say so, that in turn looks carefully upon a very long and detailed opinion prepared by Alain Pellet, Malcolm Shaw, and myself. Article 1 of the two covenants speaks of self-determination, and Article 25 is concerned with the details of how democratic free choice is to be achieved by periodic elections on the basis of universal suffrage. It deals with the entitlement of participation without discrimination in the public life of one's country, whether as a politician, civil servant, or voter. None of this is to say that democracy, the essential bedrock of continuing self-determination and the right to participate in the public life of the country, comes in only one form. But within various possibilities, there are essential elements that must be there. And the rule of law concept has gone a considerable way to fleshing out those ideas. And in the last decade, the concept of rule of law has attracted much attention. What does the rule of law mean to the international lawyer? It's not a term of international law as such, so let's begin by looking at what the term means to a domestic lawyer and see where we go from there. Dicey famously identified three principles which together, he said, establish the rule of law. One, the absolute supremacy or predominance of regular law as opposed to the influence of arbitrary power. Two, equality before the law, or the equal subjection of all classes to the ordinary law of the land administered by ordinary courts. And three, the law of the Constitution, written or otherwise, is a consequence of the rights of individuals as defined and enforced by the courts. These ideas, still valid, have been fleshed out by much of the work done in recent years on rule of law, including the so-called Venice Commission and, of course, Lord Bingham's book, The Rule of Law. Very detailed specifications are also offered by the Van Dyck report adopted by the Venice Commission in 2009. The annex to the 2011 Venice Commission on the Rule of Law offers a detailed checklist for evaluating the status of the rule of law within states. Rule of law is not my topic except on a by-win today, so I'll simply summarize without going further. There has to be legality, which means the supremacy of the law, legal certainty, prohibition of arbitrariness, access to justice before independent and impartial courts. You heard that already in Dicey, but the Van Dyck Commission has many subheadings for you to check whether that is a reality in specific cases. And the place of human rights and respect for them is also an element gone into in detail. Now, many of these elements can be recognized as human rights under the European Convention on Human Rights and the International Covenant on Civil and Political Rights. But it's much, much harder to see where the dicey idea of rule of law fits into the international system. There's manifestly no world government system into which the model could easily fit. The UN General Assembly is indeed representative of the international community, with each state having one vote. But the executive of the UN consists of 15 members, 5 of whom are permanent and hold a veto, and 10 of whom are broadly representative of the membership as a whole. These latter serve a rotating 2-year term. Kofi Annan, among others, had pushed for restructuring of the Security Council for broadly rule of law reasons when Secretary General, but the many difficulties in achieving this are yet to be resolved. If we continue to work our way through Dicey's rule of law prerequisites, we next come to the principle of equality before the law, or the equal subjection of all classes to the ordinary law of the land administered by ordinary courts. The realities of power, coupled with the promotion of their own interests, I'm now looking at the international level, you understand, means that decisions of the Security Council, while striving for a principled application based on Charter requirements, are really subject to the achievement of the possible. And that in turn means the Security Council decision-making is not always regarded as equal applicably to all. And arguments about lack of consistency in the application of international sanctions, for example, makes the point. There's been at the UN much activity, many reports on the rule of law. There have been resolutions. There's certainly been no lack of drive to breathe life into the idea, and this is obviously not the occasion for me to take you step by step through all that's been happening at the UN on a rule of law. Despite all the flood of UN reports, we still do not have a clear definition of what is meant by the rule of law at the international level. We get a sense of the enormity and scope of the concept of international rule of law when reading the 2005 World Summit Outcome document. This is essentially a statement on everything on which the representatives of the international community can agree. In that light, it's rather impressive. It covers domestic resource mobilization, debt, education, HIV/AIDS, migration, terrorism, refugee protection, and the reform of the UN Secretariat. Very hard here, really, to see an international rule of law. So I now turn to the tricky subject, of which I may have a different view from Professor Weller. Is democracy a rule of international law? As you'll know, the Council of Europe regards itself as the continent's leading human rights organization. It has 47 member states, 28 of which are members of the European Union. All Council of Europe members are required to sign and ratify the European Convention on Human Rights. And the Council has three so-called pillars: the rule of law, democracy, and human rights. And as I've already suggested, these concepts are intertwined and somewhat difficult to separate. It's hard to conceive that in the absence of democracy, rule of law can exist. And it's equally difficult to imagine that a country can have the full panoply of human rights if there is no democracy. That these concepts are intertwined is self-evident, but there are questions on which the answers are not so apparent. Is the concept of democracy really a right in the sense understood in international law? And although human rights are legal rights, is the rule of law really a legal right? Well, what is the common understanding of a legal right? It is surely a right, the fulfillment of which can be claimed as law. I don't think that either an individual or a state would be successful in bringing a claim against the state that democracy is lacking. It is much more likely that such a claim would be articulated in a national court as a violation, perhaps by reason of lack of democracy, of a human right. And in an interstate case, perhaps before an international tribunal, it's likely to be advanced as a claim that there's no real self-determination, and people do not have the right to choose their own government. As I've suggested earlier, it would not be surprising if democracy is not really a legal right. When the UN Charter, notably silent on democracy, was drawn up, as I've already said, the majority of original members and the vast majority of those who later became members were not democracies. And if legal claims could be brought against them on the ground they were not democracies, the UN membership would have been born in a state of chaos. What's interesting, given that reality, is to wonder how the great push for democracy came about. There's no doubt this has happened. Members of the UN today, in very many resolutions, are willing to condemn a military coup as contrary to democracy. States do this because it is easier for them to insist that while governments come in many forms, the form of their government is actually democratic. They will say it came to power through the ballot and has the ongoing support of the peoples. Of course, such claims may be made when ballots are rigged, when membership of the legislature and indeed the superior courts are controlled by governments, and we can all readily think of examples. And of course, if a government controls the press and TV, then it can remain popular, especially when it engages in military action overseas and presents its acts as defense against aggression and ill will of others. Fair voting for a government or a president is crucial, and that's why so much has been invested in the monitoring of elections worldwide. The monitoring by the OSCE, the EU, even occasionally by the UN itself, can of course be resisted, but that puts the government or president concerned in a doubtful light. There's now a marvelous literature on monitoring and its role in the achievement of democracy. Another uncomfortable question: is democracy, whether an important value or a right, going backwards? The close relationship of democracy with the freedom for nationals of that country. In 2014, it was reported that of 195 states in the world today, 88 are free, that's 45%. 59 are partially free, 30%, and 48 states sadly can't be classified as free. That is a quarter of the world. When James Crawford gave his inaugural lecture at this university, he was cautiously optimistic, seeing evidence of growing democracy worldwide, and strikingly in the continent of Africa. He stated that between 1986 and 1993, the date of his lecture, I quote, "the proportion of states with democratic systems, however fragile or tentative, has increased sharply. He saw this process having begun in Southern Europe, then extending to Latin America and Eastern Europe, the Soviet Union and many of its former republics, and even to East Asia. Various groups and publications today suggest that we are now seeing a year-by-year decline in what they sometimes term human rights. Some in recent years have suggested that things are going backwards so far as democracy is concerned. It is true that fewer and fewer states today insist that democracy is a Western value, which should not be imposed on the countries of Africa and Asia. That, I think, has faded. Rather, states remain silent on the matter, and all too many insist that there is a country of democracy in that they hold periodic elections. But as we know, elections are often held in an atmosphere of intimidation. The opposition is so certain the electoral process is sham that it would tell its supporters not to vote at all, and the government thus invariably wins, even if the turnout is remarkably low. Just last month, the president of Sudan, wanted by the ICC on genocide charges, was re-elected after 26 years in power on a 25% turnout. It's all too easy to think of countries purporting to be democracies engaging in elections that are not fair and free. We have to be careful not to be too sanguine. We've seen, for example, in Egypt, reversals in hard-won democracy following a military coup. Such reversals are apparently legitimized by the holding of elections with intimidation and fear in evidence, and the legitimacy of the electoral process open to question. The data in recent years suggests elected leaders are often relying on modern authoritarianism. And for example, within sub-Saharan Africa, there have been considerable improvements in the achievement of democracy, but also often a slide into authoritarianism. And many countries are in the grip of corruption, and corruption and democracy do not sit well together. There have, in the legal journeys, been interesting exchanges between academics over whether 1989 to 2010 in fact marked the high point of democratic legitimacy. These developments were traced, for example, by Susan Marks in The Riddle of All Constitutions. She focuses in considerable detail on the idea of regulating domestic democracy by reference to international law. And while agreeing with her conclusions, Professor Dastremont of Amsterdam asserts that many facets of democracy, in which he includes human rights instruments, were enshrined in international law even before the end of the Cold War. And of course, both American and European scholars have addressed the idea that democracy plays a crucial role in the international legal order. And there are many interesting articles and books expressing different views. Now I come to my conclusion. Tomorrow, this conference is going to pay honour to James Crawford. For long years, your Whewell Professor of International Law and now a judge at the International Court of Justice. He has written so much. His inaugural lecture, Democracy in International Law, has really stood the test of time. It showed that Cambridge had selected as Whewell Professor a man who thought deeply and perceptively, looking to the future as much as to the past. The lecture contained hope and hard-headedness in equal measure. And now it's the turn of the International Court to benefit from his considerable knowledge and thinking. Thank you.